everyone. A warm welcome to both our audience joining us live as well as in person today. My name is Arasha. I'm Associate Eco-Legal at the IMI, and this is my colleague Jenil, Legal Associate at the IMI. We have a special guest amongst us today, but before introducing them, we would first like to introduce our topic of discussion. It's indeed a very important one, one that we regularly read about as well as hear about and analyze as part of the digital policy and the internet economy. Our topic today is the online liability framework and protection accorded to copyright industry stakeholders in light of the expanding role of internet services. Today we're honored to be in conversation with Mr. Lauri Rechardt, Chief Legal Officer at the IFPI. The IFPI is the organization that represents the interest of the recording music industry in over 70 markets around the world. Lauri leads the IFPI global legal team, covering and coordinating legal policy, licensing, litigation, trade policy, and regulatory affairs across territories, and he's closely associated in working with various stakeholders in the key recorded music markets around the world. We welcome you, Lauri, and it's great to have you amongst us today.
Thank you. Great to be here.
I will now leave it over to you, Jen.
Thank you so much, Arasha. Thank you, Lauri, for joining this conversation. Indeed, a great topic to discuss at this point of time because we are seeing a lot of developments happening in Indian context, but we'll come to that part in the next segment. But to start off with, I just want to highlight these two trends that we are observing globally as well as in India. So on one hand, today we are seeing there has been continuous efforts made by various governments, policymakers, regulators to regulate digital services as well as to revamp or to relook at the intermediary framework in the market. On the other hand, we're looking at a continuous trend that is causing a concern to the copyright industry, including recorded music industry in terms of online piracy. So considering these two trends and from rights holders perspective, how do you analyze these trends considering that today record industry amounts or the revenues the recorded industry is reporting, 70% majority of the revenues are attributed to online streaming, digital downloads and sales?
Yeah, I mean, look, I think you're absolutely right in making the connection in that obviously it's good news that policymakers around the world are aligned to the issue, which is the fact that regardless of the high number of legitimate services that really cater to all kinds of consumer preferences, that the level of piracy, if you will, the unauthorized use of copyright content is still unacceptably high. And that's obviously, it is a problem. At the same time, we need to realize and appreciate that the level of piracy globally, actually has decreased. But the point is, it's still way too high. And that's obviously something that it is good that the policymaker, policymakers have sort of realized that. But at the same time, more needs to be done. And what we are seeing is initiatives, both in terms of actual legislation as well as then if you will, projects, ongoing legislative projects to deal with that. And it has to do a lot on the one side, clarifying the legal framework, and on the other side, then ensuring that right owners and authorities have the legal tools, if you will, the procedures and measures available to tackle the unauthorized uses. But I share your, if you will, slight bewilderment. Why is it that, regardless of the great legal offers, that people still use unauthorized services? We may come to some of the issues that may lie behind that, but those are kind of, if you will, high level, the trends that we see.
I would like to take a step backwards and sort of try to understand from you, how is the expression online liability defined historically in terms of global policy landscape?
Right. I think if you go back and that's sort of almost, if you will, pre-internet era, which is like a good 35 or 25, 30 years ago. The starting point, I think everyone would agree, has always been that what's illegal offline should be illegal online. Now, there was a time where that starting point actually was put to question, and if you will, some stakeholders and some operators that questioned and said, that somehow the online world is a kind of a world of its own where different rules would apply. Now, luckily, I think we've gone away from that. But at the same time, there has been, a realization that in order to ensure that the starting point, that what is illegal offline should also be illegal online, that actually, is realized in practice, that certain things need to be clarified. And for instance, in Europe, we have seen the Digital Single Market Directive, which clarified the legal liability of certain types of operators, notably what they called online content sharing service providers. I think you can call them user upload content services, and clarified that once you engage with content, even if it was uploaded by the users, then you engage in a copyright restricted act, and you have the liability for the content. And at the same time, we are seeing courts around the world, following then, even though there hasn't been, if you will, sort of outright clarifications of the legal framework, that the courts have interpreted the existing rules in line with, if you will, the broader principle of, again, and I repeat myself, what's illegal offline should be illegal online.
Right. So, Lauri, you've talked about internet and how, the role of internet has sort of transformed over the ages, and now it keeps growing. Technology has only grown by leaps and bounds. So, in light of this digital penetration, be it smartphone or internet, and there's a simultaneous or a corresponding increase or proliferation of platforms that sort of host unauthorized content. So in light of these, what do you think are the challenges that are faced by rights holders globally when it comes to enforcing their rights?
Right. Well, there are a number of challenges, but I come back to what I just mentioned. One of the challenges we still see in a number of jurisdictions is that the rules governing the liability of at least certain types of online services aren't necessarily clear enough. So there is space to, if you will, to improve and develop the legal liability framework. And we are seeing definitely movements towards that. And again, in Europe, we have seen important developments in that respect, both in case law by the European Court as well as the legislators. There's more and more debate around these issues in other jurisdictions as well, including the United States and elsewhere. So that's kind of the first point. But the other point, which is really important, is then what is happening in terms of the right owners or the authorities' ability to enforce the rules that are in place. And one of the big challenges we are seeing is that very often the unauthorized services and the operators, they locate in jurisdictions where enforcement either is lax or in some cases even impossible. And that means that in order to ensure that consumers in your own country don't unwittingly or otherwise access unauthorized services, that there are tools for the right owners to ensure that access to such illegal services offered from outside your country is restricted. And then, you know, in very concrete terms, measures, procedures like websites or injunctions against access providers that ensure that they don't enable access to these services. So that's an important, you know, legislative tool. So it's, on the other hand, sort of policy action in terms of crafting the liability rules so that they work, and on the other hand, ensuring that right owners and authorities have the enforcement tools and measures in place. And there, you know, obviously there are, you know, as said, the kind of tools such as non-fault injunctions against third parties whose services are used by the illegal services. So that's an important tool. But at the same time also then, if you will, more robust obligations, responsibilities for the key services, again, used by the unauthorized services. And here I refer to some obligations which are already, you know, if you will, par for the course in other sectors, such as know your business customer, and the obligation or the right of right owners to seek information about the identity of the operators and so forth.
Well, thank you for that, Lauri. So you've discussed those challenges in extensive detail, but sort of coming back to the online liability framework, what do you think are the factors there in the existing online liability regime that sort of facilitate these challenges for the rights holders and they add to the burden for the rights holders?
Yeah. Again, I think the starting point is, you know, clear rules on liability. That's the, you know, I would say the most important thing to ensure that services that if you will engage with the content, wherever that might be, unauthorized content, they must bear their responsibility. And so that's the kind of the first, if you will, step. And whether that responsibility in legal terms is you know, primary responsibility as, if you will, the actor, or contributory or secondary liability, that can be debated. But there must be the basis for legal liability, because that way you can, if you will, drive responsible behavior. The second step then is that if there are, as in many countries, including here in India, there are certain liability limitations. They are often referred to as, you know, safe harbor provisions, that those safe harbor provisions are defined in a manner that, again, drives responsible behavior, which I think in simple terms means that those liability limitations must be reserved for pure neutral infrastructure service providers, and not for services that are actually engaging with the content and offering the content. So that's the next point. And the third point, which is really important, is that for those, if you will, pure neutral technical automatic infrastructure service providers, that their liability limitations or privileges should come with robust conditions, including the obligation, you know, if on their services or networks, you know, if infringing content is detected, then they must immediately, expeditiously take it down, but also ensure that it doesn't immediately be reinstated. So we speak of notice and stay down rather than notice and take down. So again, I think the key here is that all the stakeholders in the value chain must behave in a responsible manner.
Understood, Lauri. So I'll hold on to the point where you mentioned there's a need for more clarification on the online liability rules, which is one of the main challenge we are seeing over here. So good news, India is looking at revamping the IT framework, and to achieve the goal of making internet more open, safe, and accountable. We are seeing there are movements or the approaches which government is seeing at how to revamp the IT law framework, including online liability regime. Now we see that the move that that we are observing is analogous to what EU had done recent years in terms of introducing, adopting the copyright directive, digital single market, and they recently adopted Digital Services Act. So on this note, I mean, it becomes important for us to see how the developed markets have have done modification about online liability regime, and how there's a scope for India to learn something. So before moving to that question, like I would briefly want to know, understand better, how is the online liability regime functioning currently in the EU, and how has the copyright directive, digital single market, and DSA, which is Digital Services Act, sort of tend to modify the existing online liability regime in the EU market?
That's a really good point. I think I would like to first, just say that I think it's right to say that right now, in many respects, the EU is leading, if you will, the kind of the policy developments in this space, and it's obviously it's great to see that the world's largest single market in economic terms, is doing that and really kind of, if you will, taking its responsibility in shaping the digital markets. And so you referred to the Digital Single Market Copyright Directive, the Digital Services Act. I would add a third component, which is the Court of Justice. So, and we are seeing developments in each and every one of those three fronts. And I would also say there's sort of a dialogue between the if you will, the executive legislature and then the courts. In the DSM directive, we'll start with that. There, the key, if you will, point was to, in this respect, obviously the directive covers a lot of ground, right. But in this particular aspect, it focused on actually a very specific issue, and that was the issue of responsibility of services that store and make available content uploaded by their users. So the user upload content services, and you could say that it's narrow in scope, but obviously very, very important, because we are seeing the explosive popularity of services that operate in, if you will, in that mode. And what the directive in briefly said, that once you engage in an active manner with content, even if it's uploaded by the users, then you are liable, because essentially you use the content as your own, and you offer it to your users, if you will, and you build your business on it. So the directive clarifies that once you do that, you communicate to the public, you engage in a copyright restricted act. And not only that, but you are also not eligible for the safe harbors, which is sort of a logical consequence of saying you're primarily liable for an act. You can't claim to be passive, automatic, and technical anymore, which is the criteria for a service to benefit from the safe harbors. And that's the kind of, if you will, the gist of what the DSM directive says. So it's scope, but it's very important. It really targets, a sort of a key, if you will, issue in terms of liability in the digital marketplace, and not only for music, but also for other types of creative content. Then, if you will, in addition to that, the European Court has issued actually a number of very important decisions in this space, clarifying the liability rules outside the specific sphere of user upload content services. And actually very much reflecting what we see in DSM directive, but extending those same principles all kinds of online services. And there you can see the dialogue between the legislator and the judiciary. Because at the same time, the legislator in the DSM directive was looking at the previous case law from the court. And you can see that there is actually becoming quite a coherent liability framework that extends outside the sort of the pure user upload content services and more generally to online. So that's copyright specific. Then we have the Digital Services Act, which covers a lot of ground, but essentially seeks to clarify and inject more responsibility on online platforms in a horizontal manner. Horizontal meaning that it's not limited to copyright content; it covers all kinds of content. And I think some of the main points we are seeing in the Digital Services Act is that first of all it sort of restates the online safe harbor rules, the liability privileges for online service providers, which have existed for 20-some years in Europe through the e-commerce directive. So restates, updates them slightly, but essentially keeps them pretty much intact. But then on top of that, it adds certain new responsibilities and obligations on online, different types of online platforms as they are called. And then in particular, it looks at the very large online platforms and very large service search engines, and then adds additional, if you will, responsibilities on the very large operators. And these additional obligations, they include a sort of risk assessment and also then reporting obligation as to what they have done following the risk assessment in terms of mitigating those risks. So those are kind of the, if you will, the three key pillars. We are seeing very, if you will, specific, sector-specific actions in terms of copyright, and then more broader horizontal actions in the DSA.
So basically, you explained us the highlights, how these legislations, the new legislations as well as judiciary, they, converse with each other and sort of develop, modify the jurisprudence around online liability. So what are the key highlights amongst these services that Indian government can look at, or whether can we safely assume that these legislations or these models which we hear in the EU market can set a good precedent in terms of how India can modify the online liability framework?
Yeah. Well, I would first like to take the opportunity to say that actually what we are seeing in terms of the judiciary and some of the legal decisions of late, really positive developments, where clearly the courts have recognized the problems that that right owners have in terms of enforcement of their rights, and some very, very positive, robust decisions on, in particular, in terms of injunctions against services whose services are used to enable, if you will, piracy from outside India. So that's really great news, and in that respect, India is very much at the kind of cutting edge of the legal developments. But then, in terms of the if you will, the policy developments, again, I would like to say that if we are just looking at the sort of the liability framework as such, my interpretation of the existing rules is that in terms of, if you will, the rights that exist, they are there. India has recently, or relatively recently, signed the WIPO Internet, as they are called, the Internet treaties, the 1996 WIPO Copyright Treaty and Performances and Phonograms Treaty. So they are there. So really, I think the focus or should be, to take a very hard look at the liability exemptions, the privileges that you have in the IT Act in section 79 today, and look whether they are fit for purpose and whether they are interpreted and applied in a manner that is still fit for purpose in today's environment, which is very, very different from the time when these safe harbor provisions were first introduced internationally and in India. And that comes back to something we discussed previously. The first thing is to look at the scope of those safe harbor provisions, that ensure that they are only applicable to truly technical, automatic and passive services. So the likes of, let's say, short form user uploaded content services that rely on the distribution of content should not be eligible for the safe harbors. And that's what the legislator in the EU has said very clearly. So that's number one. And then number two is, as we discussed also, is that those services that are eligible for these privileges or immunities, that those immunities and privileges come with robust conditions. So in order to be eligible for those privileges, you should take credible action to ensure that content that has been detected to be infringing, and normally it would be the right owners that notify these services of such infringements, that content is removed from the services or networks expeditiously. And then there are measures put in place that ensure that the content does not immediately come back. So notice and stay down. Notice and mere takedown is no longer, it's not satisfactory and it is not fair because of the volumes and the speed of the distribution of content on these services. And then there are other issues like credible know your business customer rules and ensuring that there's cooperation with the stakeholders, with the right owners in terms of disclosing then the information about the operator, so that right owners in appropriate cases can pursue direct legal actions if that's possible and appropriate.
So, you've given us deep insights in the various policy changes, basically the policy landscape. But coming to the industry itself, we've seen some pretty good examples, whether it's the PIPCO or the Brazil 404 operation.
Yep.
So talking about those, what do you think is the role of the industry stakeholders in sort of doing their part when it comes to online liability?
Yeah, very fair question, and I would like to say, wouldn't I, that at least as the music industry goes, is look, we understand that we have a very important part to play. These are private rights, they are our members' rights. We have a very extensive, very effective global operations to try to tackle the issue. So we understand our responsibility. I would say that we have definitely played our part and then some. But it's also clear that this problem it needs to be addressed through cooperation, and every player in the value chain needs to take their responsibility and play their part. And then and that means that obviously right owners, yes, we are trying to detect infringing activities and then notify the players or take legal actions where we must. I would say that we are sort of reluctant litigators, but sometimes there is no other option than to take legal actions. But we would much prefer to work in cooperation with what we see our partners. be it that the ISPs or other participants. So cooperation rather than confrontation is what we would prefer. And then, as we discussed, policymakers, legislators also play a super important part in essentially in ensuring that the framework within which the market operates is such that it is conducive to a fair, transparent, and responsible online environment.
I think just to summarize, coming towards the end of our conversation, just to summarize, key takeaways for me at least. One is need for clarity when it comes to online liability rules by ensuring that the scope over here is not extended to players who goes beyond passive, technical and neutral. Second key takeaway for me was that when it comes to online liability, there must be robust obligations placed in order to avail such protection under an online liability regime or safe harbor regime. I think these were like the key takeaways. I'm hoping that the Indian government, while modifying the laws in this regards, take into consideration these points. And with that, I'd like to end this conversation. Thank you, Lauri, for participating in this conversation. And first of all, these insights would definitely help us as stakeholders to make sure that these concerns are reached to the concerned authorities. And secondly, when it comes to take into consideration these points, these insights, the recommendations that you mentioned, I think it can probably, if everything goes right, could address all the imbalances which we discussed. It can also lead to a better digital music market in India. And thirdly, obviously could unlock the potential that record music industry holds today. So I think, thank you so much, Lauri.
Thank you, Lauri.
I hope
Thank you for your insights.
this session or the conversation was insight for everyone, our audience who's watching this later. So thank you so much once again.
Great to be here. Thanks.